Good evening, viewers. Welcome to Reform Studio Live, a ministry under Hillview Baptist Church that aims to discuss issues that are affecting Christians and put a biblical perspective to it. Today, we'll be dealing with the issue of estate planning. My name is Namundi Mbewe. I am your host for tonight. And I have with me in the studios State Counsel Nchima Nchito. Welcome.
Thank you, and good evening, viewers.
Okay, could you kindly just tell the viewers a little bit more about yourself?
Okay, my name has already been given. I am a Christian, a husband of one wife, a father of 4 children, and a grandfather of 4, and a lawyer by profession.
Okay, thank you very much, Mr. Nchito. Would also like to state that he is a member of Lusaka Baptist Church, correct?
Yes.
And a professing Christian.
Yes.
At that, yes, thank you. So tonight, as stated, we will be dealing with estate planning. We'll be looking at wills and trusts. And this is a very difficult, well, not difficult, but a very sensitive topic to Zambians, I believe. What would you think when we talk about wills?
I think that the problem, if we put it that way, is that most of us live our lives as if we will be here permanently. And when you are asked about a will or provisions about what happens when you die, it's as if we are wishing you to die tomorrow.
Yes.
So people don't like talking about that. But death is inevitable. Unless the Lord comes first, we will all die.
Okay, yes, that is good to know. Now we'll just get straight into the topic, and would like you to define what a will is.
A will is a written disposition of property, or a written instruction of property by a person indicating how they would like their property to be dealt with after their death. Now, because we live in a legal system, Zambia is a common law country, there are certain provisions about how a written will should be done. When you write a will, you should indicate your full names. You should have 2 witnesses who should sign that will, and they should see you sign the will. They should also sign in each other's presence. They need not know the contents of the will. In fact, it's advisable that they don't know the contents. They should just know that it's a will. The reason this is done is that if the will is challenged, the question of whether you were of sound mind when you wrote the will might arise, and the witnesses are able to testify that when Mr. Nchito was writing his will, he looked of sound mind, he didn't look agitated, he understood what he was doing, that
and
kind of thing.
was not under duress.
No, there was no gun pointed to his head.
Yes. Okay. Most people are familiar with wills. This is something that, especially in our Zambian context, this is something that people are familiar with. But there is now a new wave or trend of trusts. Would you like to define what a trust is and speak more about trusts?
Okay, so a trust is a device whereby you give property for someone to manage it on your behalf for some named beneficiaries who are not themselves ordinarily the trustees. Now, trust law essentially originated from the UK. Zambia is a former British colony, so a lot of our laws arise from there. As some of you might know, a few centuries back, women were not allowed to vote. They did not own property. Children could not own property. So when men went to war, and there was a possibility that they would not come back, there was then a need to decide how their property would be held for the benefit of their survivors. So that's essentially the origins of the law of wills, of trusts, that you give property to somebody who becomes a trustee, who holds it in trust of beneficiaries that you name. And so whether they dispose of that property and give them the money, or they rent out the property. If it's bonds and shares, they receive the dividend and then give to the beneficiaries. That's essentially to cut it to the very basic, that's what a trust is.
Okay, are you able to highlight the differences between the two? Because both have somebody who you appoint to sort of distribute the assets to beneficiaries.
Okay, the difference is that for a trust, you can create a trust even while you are living and have property put in trust for the benefit of your beneficiaries. Whereas a will only begins to operate when the testator has died. And in the case of a will, normally it's got a limited, when you die, you appoint an executor. The executor distributes your estate and they are supposed to close the accounts and account for what has happened to the property. In the case of a trust, in other jurisdictions, a trust could be in perpetuity. In Zambia, unfortunately, we have a Trust Restrictions Act that restricts the validity of trusts to, particularly for the disposal of property for the benefit of the living by a person who has died until the youngest beneficiary reaches 21 years old.
Okay, so when we're talking about benefits of a will and trust, you mentioned that a will only comes into effect when you die, and you have a trust. You can create a trust while you are living.
Yes.
Would a person who has created the trust still benefit from a trust?
If he had appointed himself a beneficiary,
Yeah.
but ordinarily I think, yeah, you can do that, but it's not normal. But you can, yeah, you can benefit if you are a beneficiary.
Okay.
Yes.
Okay. Most people do say that when you do create a trust, it can benefit you when you become incapacitated, disabled, you know.
Yeah, again, you see, let me just explain a little bit more about a trust. When you set up a trust, the person who sets up a trust is called a settler.
Yes.
And the settler ordinarily sets up a trust for named beneficiaries who ordinarily will not include himself.
Okay.
Unless you were to say that if I become incapacitated, then I can be looked after. But then we go back to the Zambian situation, which is a bit peculiar because of the Trust Restrictions Act. So you can't be looked after in perpetuity, and you are already
Above 21.
above 21. So I'm not sure that that kind of trust can really be established in the Zambian
context. Okay.
But overseas, that can happen.
Okay. So, but you would then create another policy to take care of you
Yes.
when you do get incapacitated, but not necessarily via a trust.
No.
Okay. All right. So we have dealt with the fact about which would you advise one to draft in the Zambian context? You have already mentioned the Trust Restriction Act, which talks about it not going vesting once the beneficiary turns 21. So which would you advise in the Zambian context? Which one would you advise to draft?
I think for me, it will also depend on how old your children are.
Okay.
At the time you are deciding to write the will. If you're writing it early, you can create a trust. But what would be good is to create a will coupled with a trust.
Okay.
You know, so that you appoint your executors as your trustees for the children who are less than 21 at the time of your demise. When you die, you say that if I die and my son is 11 years old, the executor of my will be hold this money, whatever is due to that person in trust, and they can pay his school fees until he reaches adulthood. Okay. So for me, in the Zambian situation, I think a combination is what would be good, because you don't want to you can't create a trust for beneficiaries who are above 21.
21.
Yeah.
Okay, so above 21, it's better that you draft a will for your children.
You draft a will and give the
wife.
property as
Okay.
it is. And for me, also maybe an important aspect about that is that we have a law in Zambia that a number of us might be aware of, the Intestate Succession Act.
Yes.
What the Intestate Succession Act has done is that it describes or apportions property for anybody who has died without a will.
Yes.
And what happens in that instance is that your surviving spouse gets 25%, your children get 50%, Your parents, if they are alive, I think get another 15%, and if you had survivors, dependents, they get 10%. If you have no parents and dependents, your children and your surviving spouse will distribute that in that proportion.
Okay, so you have talked about the Intestate Act, which we're going to talk about. Now, it has already listed, like you have said, how property or your estate should be distributed. Now, should a Christian then just say, look, the law has provided how my estate will be distributed. Why then should I write a will as a Christian?
I think that for me, the will gives you the flexibility to decide what you want to do with your property. I mean, for instance, like I was saying, when under the Intestate Succession Act, 50% of your property goes to your children, and your wife or husband, surviving wife, gets only 25%.
Yes.
If you ask me, that's a bit unfair. You married your spouse, not your children. And your surviving spouse should be left the responsibility to look after your children. So if you are happy with your spouse becoming independent of your children, then don't write a will.
Well,
if you are not, I think write a will so that you can
the
properly...
The 50% is, well, your wife still gets more if you have more than one child. If you have one child, then that child gets the entire 50%. Yes. But if you have 3 children, they share it equally. Yeah, so your wife still gets a higher percentage than your children. Yeah,
but the problem that I would see in that situation is, imagine the children are maybe 17, 18, particularly if it's a mother. The mother still wants to look after the children.
Yes.
Even if the children go and squander their inheritance, the mother will look after them.
Yes, that's true.
With less income. So for me, for that reason, I would advise my fellow men to write wills so that they leave the responsibility to look after their children to their spouses, and leave them the facilities to look after the children properly.
Okay, now that is an interesting aspect that you've brought about, where the wife would, the mother would definitely want to take care of the children. Would you say the same for men? Because I think most women do fear leaving, like if my husband gets the bigger percentage and he remarries, then what happens to my children?
I think that if you ask me, yes, even the men will do. In fact, if there is a danger, the women, depending on the age of the widow, for instance, if a woman is of a marriageable age and she gets remarried, she might end up with a husband who has a lot of business ideas for her money.
That's true.
So that might create a problem.
So I guess this is why it is advisable to then write a will, so that it does
which is
not.
Very clear.
Yes, so that then you're not worried about when they remarry. What will my children get? Now, would you have any biblical backing for drafting either one, the will or the trust?
Look, in terms of I think the will, when we look at Scripture, it recognizes the existence of a will, but also that we have a responsibility as parents to make well or to leave legacies for our children. Okay. That's a biblical position, that you have a responsibility to look after your children, and if you have acquired whatever you have acquired, it must pass on to your children.
Okay.
Yeah.
Now, when we're talking about legacies, most Christians believe that it is better to pass on spiritual blessings rather than material wealth. So they're not necessarily interested in drafting wills and acquiring enough wealth, and they just want to impact biblical or spiritual wisdom upon their children. What would your comment be?
I don't agree. I mean, we spend a lot of time working, firstly, and we acquire whatever it is that the Lord blesses us with. Okay. We have a responsibility to pass it on to our children. That's the first point. Yes, we have a responsibility to live godly lives as an example for our children. But we can't bequeath grace. You can't save your children. The Lord must save them. So if you are saying, no, I'll pass only, what are you going to pass? The opportunity, you can only pass the opportunity for them to get saved. Yeah. You can't ensure that they get saved. Okay. You can, however, leave them the property which you have acquired.
Okay, so
Yes.
another thing to note really is when you are bequeathing estate and property to your children, it is better you've also invested in them morally, spiritually, so that they should have a brain in their head or in their head to be able to take care of the wealth that you have passed on to them properly. Wouldn't you say that is something that you should also invest in as you decide to bequeath this estate to your children?
Obviously, I think, look, when we go back to what you were saying about bequeathing spiritual values, yes, you must bequeath values to your children. Okay, and the best example for children, they follow what their parents do. Children are very observant. So if you are hardworking, you love your wife or you love your husband and you show that you care for them, children will learn those things. You look after the property, you teach them to be frugal, not to be spendthrifts. Then when you bequeath them the property, they will be able to look after it. If you don't make them responsible, yeah, and we have seen many examples of people's children who 2 years, 3 years after the demise of their parents, they are destitute. Not because their parents did not leave them anything, but because they didn't inculcate in them the values to look after the property.
Okay, all right. Thank you for that. We are Reform Studios. Please like, share, and comment. You can tell us where you're watching from. You can also send in your questions if you have any questions pertaining to this topic that we are discussing. You can send them through, and we'll try our best to answer your questions. So now we can proceed to the next question. So if I was to draft a will and an executor, I appoint an executor, one who will, execute the will when I die. When that executor dies, what happens to the estate?
When an executor either dies or declines to take up the executorship, an administrator can be appointed by law. So an application will have to be made to court for the appointment of an administrator with a will annexed. He has specific instructions about he's not going to administer according to the Intestate Succession Act, but according to the will. So
Okay.
when an executor is not available to take up their duty, an administrator can be appointed.
Okay, all right. Thank you for that. Now, when couples, would you advise them to write separate wills or joint wills? And how does that look like if you do a joint will?
I think for me, separate wills are better because, you see, if you write a joint will and then one of you dies, so you have to admit a portion of the will into probate, it becomes a bit problematic.
Okay.
Yeah, what I would advise is that you write separate wills, but what might be maybe advisable is that, which I have done for one or two clients before, is that there are mirrored wills. The husband leaves everything to the wife. The wife leaves everything
to the husband.
to the husband. So whoever dies first, the property remains with the other. In terms of the law, if they were to die in a car accident or a plane accident or something like that together, the law determines that the older one died first.
Okay. So the right of survivorship does not apply when it comes to joint wills?
No, I mean, look, in terms of joint wills, they are not joint in ownership.
Okay.
There is a difference between joint ownership of property and a joint will.
Okay.
A joint will is just that you are agreeing to dispose of these things together. And that's why I'm saying that it will be, you can't be disposing, for instance, if I own a car, me and my wife own a car.
Yes.
We can't write a will together, passing on the car to my daughter as an example together. Because what happens if I die and she leaves?
Okay.
Does the car then go to my daughter? So that's why I'm saying that joint wills are a bit tricky in my view.
All right.
Yeah.
There's a question that has come through concerning the joint wills, which you have touched on. And the question reads, does one need to write a will concerning only the things that are bought in one's name, e.g. I buy a bicycle or a car, and as a couple we choose to register it in my spouse name? Can I include it in my will if joint wills are not possible?
Legally, the person whose name appears on the registration prima facie or by just
By looking,
appearance,
yes.
owns the property. So if the bicycle belongs to your wife, you can't bequeath it. It already belongs to your wife.
Okay.
She's the only one who can pass it on.
Okay, all
So
right.
because she owns it.
Okay, all right. And there's another question. There's stay-at-home moms and writing wills. You know, our culture then says that she does not work. So, what is it exactly that what then happens to stay-at-home moms?
You see, again, the question there assumes that a stay-at-home mom doesn't own anything. Now, if you hold the world view that I do, a married couple, whether one of them is stay-at-home or they are working, firstly, their income, whoever is working, whether it's the husband or it's the wife, that is their income, and it should be in a joint account.
Okay.
So if the husband dies and the stay-at-home mom remains, all the money that was in the joint account is hers.
Okay.
So she should write a will about how she's going to dispose of that property because it's hers. And I would like to believe that if you acquire real property, like you acquire houses, those should be in your joint names. If you buy a car that you say, this is my wife's car, it should not be your wife's car in name. The white book should be in her name because that's her car.
Okay.
She should be able to do with her car what she wants.
Yes.
So she will own some property.
Yes, yes.
Which she can dispose of.
There are actually couples who do register cars in both their names.
Yes, I mean you can register both, or if you want, again, yeah, it's a choice. But for me, the point is, it's not right. I don't think it makes, your wife is not your dependent. Your wife is your partner. So whatever you own, when we attend those marriage ceremonies, we hear people say, whatever I own, I share with you and I give you. It must be realized. So if we are saying this car belongs to Mrs. Nchito, it must be in Mrs. Nchito's name. It can't be in Mr. Nchito's name and then it's Mrs. Nchito's car. Why is it not in her name?
Yes. Okay. So then the whole concept of writing wills then is applicable to couples so that they can protect their spouses when they pass on and not allow the intestate act to then detect what happens to the estate when they die. So it's something that people should be considering now. Away from couples, even just as an individual, or even couples, and I say I don't have property, I don't have much to give, should I then be thinking about writing a will?
Yes. Now, look, people, firstly, the scripture enjoins us to work. So whatever I'm doing, I'm earning a living. So if I am working, there will be benefits at my employment.
Yes.
I will have acquired a bed, a mattress, a few things, whatever it is that I own. I have an obligation to decide how I want it to be dealt with when I'm not there. I should not leave it to chance.
Yes.
So I must make a decision. It's my responsibility.
Okay.
And so everybody must make a will. You own some things which you would like to dispose of. Even if they are just your clothes, you own them. So you must write your will and say that favorite shoe will go to my cousin, my specs will go to my grandfather.
Okay, so you're basically planning to die well.
Yes.
You lived well and you must die well.
That's important.
Okay, well, that's good to know. So now, how would you encourage Christians to draft wills? Would you recommend that
Yes,
Christians?
I think it's important. Look, we as Christians, we have a responsibility to look after our children, our spouses, our parents if they are still living. So we must deliberately make a decision as to how they will be looked after when we are not there. Most of us, particularly of my generation, who had parents who have either retired or their businesses have given up, we help look after them, whether you send them fertilizer during the farming season or you buy them a bag of meal if they are living in Lusaka. So if you are not there, you must make a provision for them, but also you have a responsibility to your wife and to your children.
Okay. Yep. That's good to know. Now, I have a theory. It's my own theory, and I think most people in Zambia, most men, I must say, I hope I don't offend any of the men, would prefer not to draft wills because they are not sure of how many children will pop up upon their death. Would you would you think that is
Look, yeah, I mean, for non-Christian men,
yes.
yes, maybe they have that problem. But look, regardless, unless the man ran away, he knows where his children are. The question I think that would then arise is that for that man, he would not want his wife to see the will because she doesn't know about those,
Yes, yes.
those other children. But he has a responsibility to those children if he has them, and he must provide for them. But because, in fact, if he does not leave a will, then he will leave those children destitute.
Yes, and there'd be a lot of
There will be a lot of
confusion.
problems.
Yes,
There's a lot of confusion at that point.
so whether you're a Christian or a non-Christian, it is advisable for you,
You must
to draft a will.
Yeah, you should write a will.
Okay, there are a couple of more questions that are in. So we did discuss this earlier, but the question is, please guide if a Christian couple can draft a joint will, and since all that the couple owns belongs to both of them, and the only thing that each spouse owns are his or her clothes, which are gender specific.
Yeah, like I said before, you write. It's better to write mirror wills.
Okay.
Yeah,
Yep.
the wife lives to the husband lives to the wife.
We can go to the next question. Please guide to if I can state in a will how I want my clothes distributed to avoid the drama that happens after burial, where clothes are distributed in a not so respectable manner in front of almost anyone who cares to still be around the funeral home during Isambo Yamfwa. Can one state in a will that they would prefer not to have this after burial and insensitive ritual?
Yes, if you leave a will, you can dispose of your property. What you own is yours, so you
Yes.
can dispose of your property. What you can't do, although you have not asked the question, is determine how you want to be buried. You can express your opinion, but you don't own your body.
Yes.
So when you are dead, those of us who remain will decide how we will bury you because you don't own your body. But you can decide what you want to do with your shirts and your trousers. You can say the pink trousers goes to Mulenga and the yellow shoes go to whoever, yeah. But you can do that, and
Yes.
you should do that.
I think this is very important for people to state where the clothes should go. I have my personal experience when my mom passed was that I was only given a bracelet, a necklace of hers, and then time passed. At the time she passed, I was very young, and so I didn't really think much about it. But because my aunties then got most of her clothing and whatnot, after I grew up, I thought, oh, I should have had something, of my mom, or I should have had certain clothes of my mom. And considering that fashion does come back, I was like, oh, if I inherited a few of her dresses, it would be fashionable right now. So I think it would be good if we did state where our clothes went in our wills rather than subject them to just everybody picking as and when they please and what they please. So I think that would be good to put in your will. There's nothing too small to put in a will, would you say?
No, there isn't. And but again, you see, even when you talk about, which is a bit outside the topic, about African culture and what should happen at Isambo Yamfwa, if you ask the older generation, the people who came from the villages, not us, they'll tell you what was supposed to be happening. What ends up happening in most situations now is just property grabbing. Because even at Isambo Yamfwa, ideally, the children should be the primary people to choose what they want of the remains of the parent who has died. And it's only after the children have chosen that the other people can choose. But
Yes.
again, things change depending on who's in charge.
Yeah, they do give an opportunity for the children to choose, but I just think, especially when they're young.
Yeah, when they're young, they can't decide. So somebody
Yes.
older than, then we are talking about a form of trust. In that situation, what you expect is that an older auntie might decide that, look,
I'll hold these
in trust for my niece when she's of age, or when
Yeah.
she's older, I'll give them to her. If she doesn't want them, she can have them sold off.
Yeah, I think this is something that should be considered. If you don't draft it even in the will, I think that's what we should be thinking about as aunties anyway. Another question says, please state too what the procedure is if there is a signed will left by the deceased during a funeral. Should the will be read out, and if so, to whom and at what point?
Okay. Ideally, I mean, in terms of the law will not provide how this should be done. But a good example, I mean, a good thing to do is that the same way that we do Isambwe when you've buried, before you disperse, people are interested to know what has happened, what the person decided about their property. So it should be people, the families.
Okay.
Okay, the close family should gather together.
So
and
not
the
just
lawyer or the executor should come and read the will. But I would advise that make sure that you make a copy. Go with the copy, not with the original.
Okay.
There was an incident a few years ago in Chingola or Chirilawombwe where a villager just took the will and chewed it and said, the dead man can't tell us what to do with the property that he has left. And there was no copy.
Yeah.
So there's some wisdom that must be applied.
Okay.
Because people usually are unhappy.
That's true. That's true.
Because we are expectant.
Yes.
People who say, no, Nchima loved me, so I expect that, he has left me his car.
Yes.
And then I leave the car to my son, and you're very unhappy because to you, my son is very young. How do I give him the car? So I think you must take caution, have a copy, have people sit down, read out the will, explain to them the process then after that. Having read the will, the man appointed an executor or executors. These people then need to appoint lawyers to go and have the will admitted into probate, to go and apply to court so that the will can become effective and they can begin gathering the estate and distributing it according to what the testator said. Again, maybe at this point, it is important to know that intermeddling with an estate or taking things that were not yours is a criminal offense, and you can be sent to prison.
Okay. That's interesting to note. Now, with regards to wills, you said that it's subject to probate. So there's a procedure that you go through, court process. Now the judge has to determine and then issue the probate, unlike it was a few years ago. Now, would you say that trusts are subject to the same scrutiny?
No, I mean trusts. You see, trusts are not, because a trust is incorporated under the Land Perpetual Successions Act.
Yes.
And that Act provides that trusts, for whatever reason, an incorporation of a trust is confirmed by the Minister of Lands, whoever that Minister of Lands is at the time. So if you create a trust, just a normal trust, for it to have legal personality, it must be incorporated. And the requirement is that there must be the trust deed, a specimen of the seal.
Yes.
And then you take, and now there's, I think, an application, a letter, you take to the Minister of Lands, and the Minister of Lands will sign, and it's effective.
Okay, thank you for that. We are Reformed Studios, and thank you for tuning in. Please like, share, and comment. You can send through your questions. We have Doris Musonda, who's watching from Kasama, and Doris is asking, at what point should the will be read after one's demise?
I think when you come back from burying, either that day or the following day, before people disperse, so that they know what the testator has said.
So before the close family disperses.
Yeah, for the close family, Okay. Those who have an interest. There are those who might believe, again, you see, because of our traditions, if you are matrilineal, your nephew believes that he's now the man of the house, so he's taking the house, but if there's a will, the will say clearly who owns the house.
Who owns the house, okay.
Yes.
All right, thank you. We have Kashema, who's watching from Mazabuka, and Joseph from Pundu. And Joseph is asking, does one require professional advice when he or she plans to write a will or a trust?
Okay, look, technically you don't need, but you need to know. Let's say, for instance, for a will,
yes,
you need to be very clear. You need to state your proper names yourself.
Yes.
And if you have any nicknames that are well known, you need to state them. You need to indicate that you have revoked all other wills, just in case you wrote a will and you forgot. The will needs to be witnessed by two people
Yes.
who are present when you are signing and when each one of them is signing. And then you need to be very clear about who you are giving the property to.
Yes.
So professional advice might be required to just make sure that you comply
With
with
the
the
will,
requirements
yes.
of the law. Because wills have been known to fail because they were not clear
Yes.
about what the testator
Yes.
was saying.
And not follow the right requirements to draft
Yes.
that will. Yeah.
The same thing with a trust. A trust, you must have rules. You are the settler. You must indicate what property is passing to the will, and to the trust. If, for instance, you own a house and you are creating a trust, there is a procedure then for that property to pass from you to the trust. If I've created a Nchito family trust, the property that I own that reads Nchima Nchito should then read Nchito Property Trust.
Yes.
So there is a process that I must go to lands and deeds, I must file the appropriate documents. So for that reason, if you are being very diligent and you have time on your hands, you can
do
learn,
it. Yes.
but that's why lawyers exist.
Yes, that's why we exist.
Yeah.
Okay, so we have a question from Greyford as well before we get back to our actual questions. Should concepts such as insambo yamfwa be said to be outside of the prescribed law on when you're dealing with the property intestate?
Look, when you're in the Intestate Succession Act, insambo yamfwa is not mentioned. Okay, what is mentioned in the act is just how the property will be distributed. Yeah. So what the Intestate Succession Act has done is standardize Zambian traditional custom with regard to how property devolves when you die. Now, Isambo Yamfwa, those of us who are old enough to have attended, people want to find out how you died and all those kinds of things. And so, that's just our part of our culture that people want to deal with. And who takes on the name, whether that has spiritual significance is another discussion.
Yes. Okay, so there are a couple more questions that have come through. What does the role of stewardship play in Christian estate planning?
Look, when you talk about Christian stewardship, we believe, firstly, as a Christian, there is nothing that you have that you did not receive from the hand of the Lord.
Yes.
And so what you have should be used for the benefit, for the benefit of your family, but for the benefit of the work of the Lord.
Yes.
So as a believer, then you understand that these things are not mine to do with as I want. I have a responsibility to the Lord. I have a responsibility to my family. And so in terms of stewardship, writing a will and passing property to your children and to your wife, and in that case, maybe if you were involved in some work at church that you are supporting, you want that work not to suffer, you give you bequeath some legacy to that ministry or to that church.
And I think that is something that most Christians should be thinking about, because if you do, for example, if you're mission-minded, you should also think of a way to leave money or leave a certain part of your estate to support this particular, to support missions. Also, we have people in the West who do contribute to schools. I mean, we have ACU, African Christian University. You can also start thinking about giving your estate to such institutions. So basically, how are we as Christians, how can we reflect our faith in the wills and in the trusts that we leave behind?
Yeah, again, that's a question, that's a whole subject about giving. Okay, so if you were giving and you are a regular giver, you should think about what's going to happen
when you die.
So like I said, if you had money, leave money, some amount of money to the cause which you supported,
yes.
Whether it's just your church or some missionary enterprise. Maybe if you have property that you would want to leave, But again, remember that we are told, I think, in Timothy, that the person who fails to look after his own family is worse than an unbeliever.
So, yes.
So you must look after your family
Yes.
primarily. Make sure that you provide for them. We must not become like the Pharisees who said that what I was going to give it to you has become Korban because I've given it to the church.
Yes, yes. So ideally, this would be good to leave. I mean, if you're extremely wealthy, you would definitely leave some to the church. But ideally, it would be nice to think about it when your children are above 21 or legal age and have already advanced.
I think so. But also for me, what I'm saying is that if you have some money, you can leave some money, and if you have more property, like if the Lord has blessed you and you have 4 children like I have, and maybe you have 8 properties.
Yes.
Maybe leave each one of your children and your wife some property, and maybe leave some to the church.
Okay,
Yeah.
that would be good. And a question has come in: how can a Christian ensure their wills reflect their faith? Basically, what their faith values. Pretty much what we have been
I think we have
discussing. And I think one person did mention that it would be nice to also put your testimony in a will, so that as soon as they're reading the testimony, as soon as they're reading the will, your testimony sort of comes out, and then you're able to sort of proclaim the gospel to the people.
Yeah, I think that would be a good thing to do if you're inclined to do that. Yeah.
Okay. There's another question that has come in. I don't know if we've tackled this one. What considerations should Christians keep in mind when naming executors or guardians? I think this is pretty much from as a Christian.
Yes, I think as a Christian, obviously, you should choose fellow believers, people who are trustworthy, people who you know well, that they will be responsible and they will look after, they will execute your decision in the way that you would want them done. Don't pick people you don't know.
Yes. And, family, you don't necessarily have to pick a family member. You are entitled to pick a family member.
Yes, you can pick a friend. You can pick somebody from church.
Okay, well, that's good to know. We have some more questions coming in. We have people who have tuned in and who are following. Thank you for tuning in to Reform Studios, and we hope that you share, so that we have a wider audience for this particular ministry. There's one question from Thomas Simaneka, I think. Good evening. How do you encourage your parents to consider writing a will without making them feel like you want them to die? It seems like when you talk about a will, you're wishing them to die.
Okay, I think for me, it's just to remember that we are mortal. I mean, the wise man, Moses, told us that 80 plus 10, if by reason of strength, another 10, that's about 80.
Yes.
So those of us who are getting close to that time should write our will. But I think that for me, as soon as, excuse me, as soon as a person begins working and earns an income, they must think about writing a will, because they have something to bequeath. I think that in terms of your parents, tell them that it is good for them to decide what they want to happen to the things that they own.
So without sounding like the prodigal son, I want my
no.
share.
You are just telling them that it's important. We want to effect, you should tell them that you want to do what they would be happy with. And the only way that can be done is if they let you know in the will. Not telling you, but writing a will.
Okay.
Yes.
All right. Moses is saying, great program, great lessons. Elliot Munsanje says, good evening. Does culture have a role to play in why Africans do not entertain issues related to wills?
Yes, it does. I think we had mentioned earlier, the problem is that in Africa, we believe, in traditional African belief, that if you name something, it's going to happen.
Yes.
Okay, so the power of the tongue.
Yes.
So if you begin asking me to write a will, I'll die.
Yes.
Now, there is no connection.
No.
So, but we believe those things, even some believers, there is some sublime adherence to that, to that view. But we should discard it. We know that after you are born, the next thing is you will die.
Yes, that's true.
Like I said, unless the Lord comes first.
And also understanding that God is sovereign and that your tongue doesn't necessarily have more power than what God has ordained for your life. So if it so happens that you die after drafting your will, then
It's just,
that's
that it was meant to be.
yes. Okay. Moses is asking, how best can a will be kept? What if your lawyer dies before you? This is assuming you've kept the will with your lawyer.
Okay, I think firstly, if he's a lawyer who's practicing and the Law Association of Zambia, he's got a license, he will have a place of business.
Yes.
So he will have a secretary. The Law Association of Zambia has provisions for if the person was a sole practitioner, if a sole practitioner dies, the Law Association of Zambia appoints somebody to take care and close down his business.
Yes.
So if you was keeping your will properly, they will look out for you and hand back the will or ask you to give it to another lawyer.
Okay. Chiluba Moyo says, your wife is not your dependent, she's your partner. Love to hear it. So she's making reference to a comment that you made. There's another question that I think we dealt with from Sipiwe. It says, Mr. and Mrs. Piri owns 3 properties jointly. How should the will be done in that case? And you earlier alluded to this.
Okay. No, I didn't. I think, I don't know, maybe
Yeah.
I did. But for me, if you own the property jointly, there is no need for a will.
Okay.
Because the law as regards joint property is that when one of you dies, the
The right of
surviving person
survivorship.
owns all the property. So the only person who can write a will is the survivor.
Okay. And I think this needs to be sort of clarified because you can own property jointly and as tenants in common.
Yes.
So most couples should consider doing joint tenants rather
Yes.
than tenants in common, because then if you go tenants in common, the share of your spouse is subject to
To a will.
to a will, yes, or the intestate act if you have not.
Yes. So maybe to
done a
clarify
will.
for the viewers is that in terms of the law, when you own property jointly, it's not severable. You can't separate it.
Yes.
So when one of you dies, like even if you have a bank account, a joint bank account, if I have joint bank accounts with my wife. If I die now, all the money that is in that account belongs to my wife. So when my cousin comes from the village and is looking for akabuku, it's useless to him because he's got no right to that money. It passes to my wife. If you have property that you hold in common, it is severable.
Yes.
Okay, so the portion that you own, it's assumed that you own 50-50. So if one of you dies, the other 50% that has remained must devolve according to a will, if there was a will. If there was no will, it will devolve according to the Intestate Succession Act. And if you had property in common, what normally will happen, unfortunately, is most likely that property will have to be sold because your spouse is not maybe able to buy out your share
yes.
and give the people who are entitled to your estate, because you remember there was your parents and your
Yes,
children.
yes.
And unfortunately, we have seen even children quarreling with their parents when one of the parents dies.
Yes, yes, that's true. Taonga says, since we're getting free legal advice, how can we encourage our parents I think this is also another question from the same question from a different person. How can we encourage our parents to write a will without seeming like we want them to die? What scripture can we use to back our encouragement?
I think that they have an obligation to leave a legacy for their children. I think Proverbs 13, verse 22 says that you have an obligation to leave a legacy for your children. So you are just telling them that you, as our parents, make the decision how we are going to share what you have earned. Don't leave that problem with us as children. We might not agree. The oldest might believe that he or she is entitled to a lion's share, but if they leave a will, they will say exactly how they want the property to be dealt with.
So we did discuss earlier about Proverbs 13:22, which
Yes.
is a good man leaves his inheritance to his children's children's children. And we did state that it doesn't necessarily mandate them to leave to their grandchildren or to even their children. So Could you explain a bit more with regards to Proverbs 13:22?
Okay, for me, the way I understand Proverbs 13:22 is that it makes an obligation, yes, to leave a legacy for your children and their children, but it passes. I believe that my primary obligation is to my children. So if I leave property for my children, and I have taught them how to be frugal and how to be good stewards, it will then cascade from them to their children. That's how it will pass. It's not for me to decide to bypass my son and give to my grandson.
Okay.
I don't think that's right.
Okay. So now, if you have a child with special needs, would you be able to take care of them through a will, or would you best advise somebody to draft a will?
I think
Or
that
a
for
trust,
me,
sorry.
a trust might be better, but we would have to get a bit ingenious on how to circumvent the provisions of the Trust
21.
Restrictions Act.
Yeah.
I mean, I'll say this as many times as I'm asked. The act is overdue for amendment.
Yes, it is. Okay. So what steps should one take if they're interested in drafting a will or a trust?
Okay, I think that for me, these days with AI and all these things that we can use, elicit the help of AI. But then, if you are in Zambia, when you have done your document, I think elicit the advice of a lawyer, so that he or she can confirm for you that the AI was correct in advising you. And then, like we said, if you have written a will and it's confirmed it's correct, you must then have it signed in the presence of two witnesses who must sign in their presence and seal it and then secure it in the way that you think best. You can leave it in your house, but that's a problem maybe.
Yes.
So maybe leave it with the executor, leave it with the lawyer themselves, or somebody else that you can trust that they will not open it.
Or your pastor.
Yes, or your pastor.
Yeah. Now, there's that thing that we have not dealt with. Have you ever heard of the term trust fund baby?
Yes, I have, and I think that fortunately for us in Zambia, it will not apply too much.
Okay.
Trust fund baby refers to people who have come into, whose parents or grandparents had property, or were very rich, and then created trusts for their children and their children's children and their grandchildren. So people are entitled maybe when they reach 21 to begin getting an income out of that trust. And if those benefactors were very rich, those people don't have to work. I think that's where the concept comes from.
So,
but in our instance, where we don't have perpetual trusts, it will not survive beyond the 21 years of the beneficiary. It has to be dissolved unless it's recreated.
You can only be a trust fund baby up until the age of 21.
Up until the age of 21.
So then what happens when you reach the age of 21?
In our case, then the trust should indicate what happens to the trust property, who benefits. If it passes to you, at that point, then it devolves to you.
Okay.
Or if there were 5 of you, it devolves to the beneficiaries in equal number, in equal share, and then they can decide what they want to do with that legacy.
Okay, all right. We have a few more comments and people who have liked. Cynthia Movanga says, very informative. There's a question from Mapalo Flakati. Great topic and insights. How early would you advise a young person to start working on a will?
I think I said as soon as you start working, you have an income.
Yes.
And in the misfortune that you die young, you will have left some property. You may have bought a Vitz, you may own a flat, or you bought a piece of land, or even just your benefits from work. You
or
want
a
to
spoon.
decide. Yeah, or at least you have some spoons, we hope.
Yeah.
So I think as soon as you acquire some property and some independence, you need to begin thinking. And then the other thing that we must understand is that it's important to revise wills as your property changes. But also there is a normal device in a will. What normally a will will say is that you distribute all the property that you know, and then there's what is called residue.
Yes.
If there was property that you did not provide for because you
Update
hadn't
your
acquired
will.
it at that time, you then should decide who gets that, in what proportion.
Okay. So that is what Glow is asking. Glow is watching from Lusaka. How often should a will be updated?
When you acquire new property. I mean,
Okay.
if you had...
As soon as you acquire new property.
As soon as you acquire new property, you must revise your will, because if it is not provided for and you haven't provided for a residue, it will be like it's intestate.
Intestate, yes.
So they will have to distribute it according to intestacy.
Okay, thank you for that, State Council. We have a few more questions before we wind up. There's a question that is from YouTube. Kapambwe Sendiloka asks, how can you include liabilities in the will? If so, how should you phrase it?
Okay, liabilities in the will, they must always be provided for. If a will is done professionally, it will provide, or even if you are doing it yourself, you will order your executors to settle your liabilities before they can distribute your estate. So if you had a loan, if you owed somebody money, you must indicate that I owe Mr. Nchito money, please pay Mr. Nchito money. It's 500 kwacha, and only when that is done is then the estate left for distribution.
So what happens if you did not include
Look, again,
liabilities?
if the people can, usually, again, it's an obligation. So what then happens is that even if you haven't included, the executors have a responsibility to settle your liabilities. The only difference is that the liabilities which you have not named must be proved.
Yes.
I must produce evidence. Is there an agreement that you borrowed money from me? Did I supply you goods and I have an unpaid invoice? And usually you will see executors advertising in the newspaper.
Yes.
The problem, obviously,
we don't read newspapers.
No, that's not even what I'm worried about. In a place like Zambia, some of you may have heard of Interpol Matero. People can go and create invoices that the owner didn't know about and claim that this person owed them money. So sometimes it's a balancing act.
Are these people able to contest your will if it was not included? If
No, I mean, what they will do is that they will claim that they have a debt that must be paid.
No, I'm talking about the people who you owe money.
Yes,
Are they able to contest, if genuinely you owe money, they've proved there's a contract, are they able to contest the will?
No, they don't contest the will. They ask to be paid before the estate is distributed.
Okay.
So what they do is that there is almost like an order of priority. Okay.
Yes.
When a person dies, usually the things that are paid off their will is their funeral expenses, maybe, and then if they owed money, and it's what remains that then remains for the estate to distribute. But that's also then at this point a reason that we must live properly. We must not live above our means. I might have a house or 3 houses, but I've borrowed, I went and bought a Bugatti, and so when I die, the owners, the dealers will come and sell all my 3 houses and get their money, and my children will become destitute.
Yeah,
That should not happen.
All right, as we wind down, we have one more question from Chirambo. We are seeing an increase of cases where the trustees are being taken to court. What is really better, wills or trusts? Can you have both? We have alluded
Yes,
to
I
this
think
a
that,
little.
look, the question, it's about, the important thing is the people you appoint to look after your property, whether it's as executors or indeed as trustees. They must be people of integrity who discharge their obligations.
Yes.
Yeah.
Okay, as we wind down, did we answer the question of where is it best to keep your will?
The pastor or the executor.
Okay, so what would...
Or you can actually lodge a will at the High Court.
Yeah.
Yeah, so there'll be a
The
copy.
High Court,
Yeah. No, but I mean, they'll keep a copy.
fragmented.
They don't keep all of them. So if you are lodging at the High Court or at the Miscellaneous Deeds Registry
Yes.
in lands and deeds, you keep a copy. You must keep a copy somewhere else. The only thing is that you want to certify that there was a copy that was lodged on this day. So
Okay.
that people, somebody did not go to Interpol Matero and have a will written when you didn't leave a will.
All right, so our last thoughts with regards to wills and estates. How then can the gospel shape our minds to start thinking of drafting wills and trusts? And what would you then, your last thoughts to the Christians on how they should
For
do
me,
estate planning?
For me, firstly, I think my last thoughts would be, in fact, at this point, to non-believers. We've talked so much about property, okay? Yes, property is nice. It's good to acquire property, but the scriptures remind us, what shall it profit a man to gain the whole world and yet lose his own soul? So the most important thing that you have a responsibility over is about your destiny. You know, we are reminded in the scriptures that for God so loved the world that he gave his only begotten Son, that whosoever believes in him should not perish but have eternal life. So if your relationship with God is not right and you are listening, your first duty is to make your relationship right with God. After that, then yes, be a good steward of the other things that the Lord has given you. But you must be a good steward of your life first.
Yes, because then how can you steward everything else if your life
You
is
can't.
a wreck? Yes, that's good. No, thank you very much for having joined us tonight. And thank you, viewers. Thank you for your comments. And we hope that this has really benefited you. And as he has said, we need to be great stewards of our lives and have the question of what does Jesus mean to me and how can I be a great steward to everything that he has blessed me with. So that is all from us tonight. Thank you and have a
Thank you
good
very
night.
much and good night.
Yeah.